Said by the barrister.
Good evening. Good evening. This is John Milburn for Laws 11059, Statutory Interpretation. This is week 6 of term 3, 2017. We're dealing with intrinsic materials, the components within a statute that assist you in interpreting the statute. So it's based on chapter 6 of your text. There are some general propositions that you might want to consider. And as a guide, it's always useful to keep a couple of cases, a couple of pieces of legislation up your sleeve, as it were, for ready reference, that can have a general effect or a general application. So one, for example, that you might want to consider in that regard is K&S Lake City Freighters against Gordon and Gotch. It's a High Court decision. It's a little old, from the mid-80s, 1985, 218 CLR 216. And the quote from that case that I think is relevant in a more general sense is this, that we cannot simply read the words of a section of an act and apply them without looking at the words of surrounding sections and indeed the whole act. That statement by the High Court is a statement that is now well entrenched and used. So if you find yourself having to argue that it is important that you look beyond the section of act, even though I shouldn't think that's controversial now, that would be an appropriate authority to cite to support your proposition. I will make one comment, though, about that. When people are in practice in law, typically you're very busy, you're under time constraints, you're under constraints from your employer, or if you are the employer, for your own business activities, to get a job done quickly. And if, for example, you go to the Property Law Act and you look at a certain section, then it may be clear in itself. And you may ask yourself, do I have the time and the resources and the financial backing to consider the whole of the surrounding sections and indeed of the whole act? So the High Court have said that's what you're required to do. And I think that's the appropriate course of action. But I'm just cautioning you as a practical means to move fairly quickly through that process in certain circumstances where you believe it's fairly straightforward what the section of an act says. So don't feel compelled to go too far, is what I'm saying, and read the entire act for the purpose of simply complying with what it is that the High Court says you should do when interpreting a particular section of an act. I hope that has helped rather than caused any concern to people about what I mean in practical sense. If you have any questions, please unmute your microphone and or just use the chat facility. And thank you very much again for everyone for joining us this evening. All right, so just a few words about the second assessment. I note that what has caused a bit of concern is the factual scenario in the second question for the second assessment. And what you'll find is that it is a fictitious piece of legislation based on a short factual scenario. And have a look at additional resources if you're struggling to find the material that you need. And I think Michael has posted something on UCrew or Moodle that might assist in tracking that down. So thank you. If there are any questions about the second assessment, let us know, either now or through UCrew. All right. We'll move on. So in terms of general provisions that you might want to keep available for future argument, another comes from a very important case, probably the case that you should think about first when considering issues to do with statutory interpretation. And that case is Project Blue Sky, Inc. against Australian Broadcasting Authority. It's a 1998 High Court decision, 194 CLR 355. That's the go-to case, I think, in statutory interpretation. And one of the things that you might consider from that case is the basic proposition from the High Court that some provisions may be leading or dominant provisions, while others may be subordinate. Now, I'm not going to give you an example of that now, but keep that in mind that when you're reading pieces of the legislation, not every word or sentence or section necessarily carries the same weight as other words or sections from the particular act. So Project Blue Sky says some of the provisions are leading or dominant, others are subordinate. Keep that in mind. And you'll find that reference in your text as well. Okay, long title. Traditionally, legislation includes a long title at the commencement of the Act. Excuse me a moment. And a short title. Now, the short title is really meant to save time and provide an ease of reference. But in your text, you'll see that there's some examples, or at least one example, of where the short title can actually provide more information than the long title. So short titles may be used in interpretation. Don't ignore them. Usually, the brevity means that you can't use it effectively. But the example in the text is the Tax Laws Amendment, Temporary Flood and Cyclone Reconstruction Levy Act, 2011. That tells us quite a bit about the intent and purpose of the Act, as opposed to the long title, which is an act to amend the law relating to taxation and for related purposes, which tells us nothing. So usually the long title gives more information, but not always. I guess the distinction that you could make is this, that the long title sometimes deals with the purpose of legislation, and the short titles sometimes deal with the intent of the legislation. If you haven't already done so, you should be creating, I guess, some lists of things that you can rely upon when referring to issues to do with purpose or intention. What is the difference between purpose and intention from a statutory interpretation perspective, do you think? Can you summarise that for me in a simple manner? Any thoughts?
Would it sort of be like the purpose is the overall big picture while intention is more for provisions and stuff and adds to the overall purpose?
Yes, I like that. Yeah, that works for me. Any other thoughts on how you might describe statutory purpose as opposed
Is the intent?
Yes, David?
Is the intention the original underlying reason for the Act to come along, and the purpose is actually more the specific way in which the Act will operate in order to fulfill those intentions?
Arguably, I would probably go the opposite of that and actually switch them around. Any other thoughts? Not necessarily.
John, it's Grant.
Yes, Grant.
Would the purpose be wrapped up in what it's trying to achieve and the reason for doing it, and also incorporating a reason, whereas obviously the intention is, you know, what you're trying, what your intention is, you know, what you're trying to do for the future?
Yes, I think that's pretty close. Now, my view on this may be different to your view. And the reason I'm suggesting that you create a list under these words, statutory purpose, statutory intention, is that if in the exam question you want to refer to the purpose or the intention, you've got something to rely upon. For my part, statutory purpose focuses on issues to do with why and who. Statutory intention focuses on what and how. I think that's consistent with the textbook as well. So purpose looks at why the legislation is needed and who it's directed towards, whereas intention is concerned with what is done to meet the purpose and how should it be implemented. So David, what I'm saying now, is that consistent with the answer I gave to you?
Yes.
Okay, that's fine. And feel free, of course, to find authority to support your original proposition if you wish, and we'll raise that through you, crew. All right, preambles. We don't see preambles much anymore. They were common in older pieces of legislation. You may come across a preamble, which was an introductory statement. I guess it set the scene, describing the background and motivation to creating a document. Preambles are still common in international treaties and resolutions of the United Nations bodies. They're often used in constitutions, but they're no longer widely used. In fact, they're quite rare. Has anyone come across a preamble in your searches? I don't think you'll see them too often. All right, so traditionally a preamble was not used as part of interpretation unless there was some ambiguity. The courts didn't see the preamble as part of the Act itself, but that changed, and the Commonwealth provides for Section 13(2)(b) that the preamble is now part of the Act. That's a handy provision, but it's largely not going to be useful in practice to you. What is useful is the objects clause. Now we know that, so when you're looking at interpreting a statute using intrinsic materials, we dive for the objects clause, I think, as a starting point, after we've skimmed through the Act and we've looked at the headings and got a general feel for it. So the objects clause assists in communicating the purpose of the legislation. So there's that word again. The objects clause are commonly included in the commencement part of the Act, usually clause 3 or so, or section 3. And where it does appear, it can clearly be used in interpretation, there's no doubt about that. That's its intent. And there are some basic rules. It is not meant to be exhaustive. So in other words, you can still look at other places to get a better idea of the purpose and intention of the legislation, intrinsically and extrinsically. So tonight we're dealing with primarily intrinsic materials. But you can look beyond that, and of course we're familiar with the standard extrinsic materials, second reading speech and explanatory note or explanatory memorandum. Other than that, what's the next? I know we're covering ground that we've covered, but this is the nature of this week's course unit. What's the next place that you'd look for interpreting the legislation?
Objects clause.
Yeah, well, we've just done that one. Yep. So after the objects clause, where would you look?
Definitions. Definitions.
Yep, exactly. Definitions. Can anyone tell me a little trick that sometimes you need to be careful about with definitions? That's a very vague question, I know.
Generic meanings.
I'll just invite you to use the microphone if you're not speaking. Just getting a bit of background noise. Usually as the person starting the meeting, I can go in and mute microphone. I'm having trouble hearing. Tanya, so you there, Tanya? No, I can't do it. Tanya, are you there? My apologies. I can't even remove Tanya. So all my usual tricks aren't working tonight. I don't know why.
Could we all sign out and then sign back in again or something? Would that work?
That might work. Well, it'll break the recording, so I'm just trying to avoid that. Okay, look, we might be okay now, so we'll continue. Can you hear me okay? I'm sorry about that delay. All right, so what's the trick about issues to do with interpretation or definition sections, rather? It's only a little trick.
Generic language and
Yes, yeah, generic language. I guess what I'm really getting at is this, that sometimes the definition section is, the definition is particular to a part only of the legislation. In other words, some parts, some chapters have their own definition sections. So you've got to be aware that it's not just a case of going to the definition section generally, and that will cover everything. So for example, in the Uniform Civil Procedure Rules, if you're looking at making an application for summary judgment, there are special rules that apply to the amount of time that you need to give by way of service to the other side, which is built into that particular part of the UCPR, which doesn't apply generally. So sometimes there is that little trick that you need to be aware of. So now it's very common for pieces of legislation to include definition clauses. They can be lengthy. The example given by the author in your text is 44AB of the Competition and Consumer Act. So take care when you go beyond the definition of a section for the general effect of that definition. And a little case to consider, Kelly against the Queen, 2004 2182 CLR 216. A definition is an explanation of a word or phrase to assist in interpretation. It is not a substantive legislative provision. So Kelly's case provides some indication as to the extent that you can use a definition. All right, so last week we spoke about words that are exhaustive or non-exhaustive. And the same applies for principles of statutory definitions. And it's pretty basic, but look out for things where the definition is framed with words such as the certain thing means something, as opposed to a certain thing includes something. So if it means something, that's exhaustive. It's a complete definition. But if it says it includes something, they're really examples and they don't limit the definition from including other things. So the telecommunications case was a good example of how TV broadcasting was included in a list of definitions, even though it wasn't specifically mentioned, because of the word inclusive as opposed to means. All right, did you have a look at the example exercise 6.1 in your text about John, the Qantas 747-400 captain? Did you all have a look at that? It's a good example. Okay. Does anyone want to tell us about that exercise, what it means for us, how we can use it in the context of statutory interpretation? Just giving you a chance to hear someone other than me, that's all.
That's coming back to his age. So, you know, that's the main point. He's 60 years old and he's a pilot. Does a company policy from Qantas allow them to break that law, I guess?
So there was nothing that said that he was not able to fly an aircraft. He still had the skills, the fitness, all his faculties available. As a 60-year-old, he could still fly the jet. Why couldn't he have just been offered shorter routes around Australia or perhaps to places like New Zealand, Fiji?
He was international department, so that meant that he could end up anywhere. So he might fly to Munich or Singapore, and then the pilot's sick and he'd have to fly on to Munich or something like that, or Dallas. Therefore, you get a long trip, and he may be too old for that. So
who would say that he's too old, though?
The company policy.
Yeah, but isn't that the idea of challenging the company policy, to say the company policy is wrong?
Oh, absolutely. That's
Okay.
that's Qantas' stance, hence why he's got this predicament.
Yeah. Okay, so John relied on the Industrial Relations Act, Commonwealth, Section 170DE, and it said, An employer must not terminate an employee's employment unless there's a valid reason connected with the employee's capacity or conduct. So in this case, Qantas was not saying anything about his capacity or conduct. So why was Qantas able to successfully dismiss John? Michael says it's because he may have to fly into places like Munich or Singapore. Is there more to it than just company policy? Okay, so Grant, I think you're getting pretty close. What do you say?
It's something. This is just something from my own sort of experience, but I believe it's under the Fair Work Act, where if someone has been, or there's evidence that someone has a condition or requirement which does include age or a disability, and that affects the inherent requirement of that task. Say, for example, a person flying a plane who is blind obviously can no longer fly that plane, so you're well within your lawful right to unfortunately terminate them because it's deemed an inherent requirement of that task.
But John was still physically fit, he was still physically capable, and in fact he relied on Section 170DF of the Industrial Relations Act to say that an employer must not terminate an employee's employment for any one or more of the following reasons, or for reasons including any one or more of the following reasons, and he relied on age. So he's saying, well, under the Industrial Relations Act, firstly, you can't terminate me unless there's a valid reason connected with my capacity or conduct, and you certainly can't terminate me because of my age per se. And yet Qantas still won.
Sorry. Well, they're saying they have to specially create a position for him because he wouldn't fit into their standards.
That's true. But what were these standards? I guess what I'm really looking for is something beyond just what Qantas says as their standard. Any thoughts? We're getting close. We're getting close.
John, do you mind just repeating that? You vanished there for a bit, sorry.
Oh, sorry. Okay, so we're getting closer with what we're saying there. But what is it beyond Qantas's own standards that had a distinct bearing on this case that was highly relevant? So Melissa says different zones have different rules on age. Nicole says international rules, law has restrictions.
So
Grant says the inherent requirements of a job. Benjamin says Human Rights Commission. Nicole says because an age was an inherent requirement for international flights. Okay, so what do you mean by that, Nicole? You're right. Do you want to elaborate on that? Okay, in order to fly in some countries, he needed to be under 60, and that's it. So, because of issues that were not directly related to Qantas, that were in a sense imposed upon Qantas, Qantas had to fit within those external requirements, and that meant that even though he was still capable of flying the jet, he was not able to cope with the inherent requirements of the task, and therefore Qantas was entitled to dismiss. And in that case, the court said that Qantas didn't have to go beyond that and create a position just for John. All right, so have a look at Qantas Airways against Christie. It's 1998 193 CLR 280, and the trial judge and the High Court majority held that it was an inherent requirement of John Christie's position that he fly all international flights, which is a point that you were making. And in coming to that conclusion, here's the statutory interpretation point. The High Court looked at the whole context of his employment, not only his physical capacity to fly aeroplanes, and concluded that being under the age of 60 was an inherent requirement of the job. So many of you identified that. But I guess the point that I'm really trying to make is this, that when you argue for a certain position based on statutory interpretation, you need to support it very precisely and, where possible, have sections or cases or specific facts of a case that are relevant to the circumstance. Okay, headings. Now, are headings part of the statute? Can you take into account the words of a heading in trying to argue for a particular interpretation one way or the other? Or are they
Yes.
just for convenience? Yes, Sarah. Do you have any authority for that?
Well, it's in the Acts Interpretation Amendment Bill from 2011, according to the textbook. I was looking at it a little while ago. Just let me see if I can find the other reference I was looking for.
You're absolutely correct. Does anyone know the specific section? 13 says Nicole. That's it. Does anyone know the subsection? 13D2. All right, Benjamin had that as well. Okay, so the explanatory memorandum to the Acts Interpretation Amendment Bill explained the depth to which material and legislation could be considered in the context of interpretation. What I draw from that is this, that you need to have specific authority to support a proposition, and the second is you need to consider the explanatory memorandum to the amendment bill that created the change that is now incorporated in the Act. So to do that, you need to develop the skills of finding when it is that the amendment occurred and being able to trace back then to the explanatory memorandum at a Commonwealth level or explanatory note at a state level relevant to that change, so that you can support your argument about purpose and intent based on the those extrinsic materials. Does that make sense? And the final exercise that you have for this term in the invigilated online paper, the Proctor-U paper, requires you to be able to do that. Okay. Just to digress for a moment, has anyone had a look at the sample paper that I prepared? I take it you've all seen it. Okay. Do you think you'll be able to do that or not? Yes, Sarah?
John, just out of a curiosity, is it a typo on that sample paper that it says the Health and Safety Act 2001 as
Yes,
opposed
it should
to
be
2011?
2011. It should be 2011.
I saw it there and I'm like...
I don't know why. I just keep saying 2001, but it was 2011. It is a typo.
Okay.
Thank you. So has anyone had a go at answering that question or trying to do it within a time frame?
It's on my to-do list after I do the
Yes.
next assessment.
So, yeah, I think after you do the second assessment, then everyone will attack that sample paper. I'd urge you to do so. The real paper is not going to be far different, to be honest. We know it's on the same Act, and you know the sort of questions that I'll ask. So it's the best preparation you can do. All right. Now, did everyone have a look at exercise 6.2, lost in transit? It was to do with the business contracting a freight company to carry a consignment of magazines. Does anyone wish to tell me anything about that case? How it's relevant to statutory interpretation? Anyone brave enough to take the reins? All right, so what was it about? What if we break it down? What was this case about?
A contract stating that that they have no fault basically in an accident, and then there's been a negligent part of it, and then they're contesting that, the fact that, well, if someone performs a negligent duty, things arise from it. Yeah,
I don't think there was any doubt that the loss that was caused as a result of a collision, which occurred because of the carrier's delivery company being driven negligently. So that occurred. Yes, Sarah?
The contested point was whether the damages could be claimed for damage to property as opposed to just personal injury.
Exactly, yes. So can it be recovered for the loss of goods? Or is it just personal injuries, losses? So what was the relevant section in that case that needed some interpretation?
Section 133 of the Motor Vehicles Act 1959, South Australia.
Okay, good. That's it. What did that section say?
Do you want a direct quote of the section?
Yes, please.
Okay. Any contract, whether under seal or not, by virtue of which a person contracts in advance out of any rights to claim damages or any other remedy for the negligence of any other person in driving motor vehicle, shall to that extent be void.
Exactly. There's a lot of words in that section. I don't think that Parliament would create a section with so many words now to say that. What I took from that, from my notes, was any contract where a person contracts in advance out any right to claim damages for negligence shall be to that extent void. Okay, just a little bit lighter. Okay, so we have a situation where we have a carrier who says that Section 133 only applies to bodily injury. What did the court find?
That the section was not limited to only personal injury, it also covered property damage. I think the thing was that the heading to the part did not limit its operation.
Okay, and the real case was one that we mentioned earlier today, K&S Lake City Freighters against Gordon and Gotch. So the High Court majority decided that the section covered property damage as well as personal injury, and the heading to the part did not limit its operation. So the heading was, I guess, misleading, is essentially what the court was saying. Two judges saw that the heading is not inappropriate and the provision could not be read down. Another judge simply reasoned that 133 operated independently of the other sections. So again, we have a situation where the High Court judges are deciding things based on different reasons. Schedules. All right, so what's a schedule? When do we use that? When do we see it? I'm sure you've come across schedules in legislation already.
Well, a good one is the ALC, the Schedule 2 Competitions of Computer.
Exactly.
It's a extra set of provisions relating to a concept of an act generally that doesn't normally fit within the act itself.
Exactly, and a schedule in that sense was with the Australian consumer law is takes on more importance than it would be if it was a regulation, which would be the other way of doing it. So if it's a schedule, here's the important part, it is a substantive provision of the Act, because in the Act itself, it will refer to the schedule and give it the force of the legislation. Okay, notes. What do we know about notes? And what are the different types of notes that you might see in statutes?
John, it's Grant.
Yes, Grant.
There's heaps of notes, margin notes, head notes, footnotes, toe notes. There's plenty of them, and they generally appear at the end of the legislation, and they're added as like a change to, or typically added at the first draft stage.
Very good. I haven't come across a toe note. What's it? Did you say toe note? But yes, there are lots of different notes. Are you allowed to take them into account in interpreting a section or an act? And if so, what's your authority?
You are allowed.
Yes, Sarah?
You are allowed to take them into account, and the authority is with the passing of the bill, because a bill gets passed in its entirety, which includes all material, including the notes, when a bill is passed, and thus they have the same authority as the legislation.
Is there any reference?
It's 35(2) of the New South Wales Act. Let me see if I can find the Commonwealth one.
Okay. And in Queensland, while Sarah's looking at the Commonwealth, what's the Queensland provision? Ben?
Oh, I was just going to say Brevington versus Godalming.
Okay, I wasn't.
It's authority where a note has been used as part of statutory interpretation in common law.
Okay. Well, Mike, I don't have a note of that case. Can you give us do you have the citation there, Benjamin?
Yeah, Brevington v. Godalming, 1988, 169 CLR 41.
Thank you. I appreciate that. Melissa says section 13 from Queensland. 35C Queensland.
35C, yeah.
Yep, 35C. And section 13.3. Sharon and Melissa said that. And I agree with those things. Is that consistent with what you've got there, Sarah? And Michael says, what is it, Michael? 35 in Western Australia. So we've got Michael and Sarah from Western Australia, I think. Okay. Punctuation. Punctuation is part of the all material and therefore included in the interpretation. Have a look at section 14.5 of the Queensland Act. And examples. Examples are great. When you come across an example in legislation, it really does help. And it can be used to interpret the provision, but it can't override the substantive provision. Is there a section in the Commonwealth Act that says that?
15 AD.
15 AD, thank you. And finally, this is probably pretty obvious, but penalties, unless stated otherwise, all penalties are maximum. They're not mandatory provisions. So that's 4D of the Crimes Act, Commonwealth, and 41 of the Queensland Act. You notice there that that is the only section where we're not comparing directly the Acts Interpretations Act. We've got an introduction of the Crimes Act, which has a bearing on the interpretation at a federal level. All right, well, that's all that I wanted to cover this evening. Do you have any questions, comments?
I have a quick question with regards to the second assessment. Well, actually, I have a couple of quick questions.
Please.
The first one is in regards to the first part. It says we are creating something like the cool toolkit we did for intro to law, but for statutory interpretation. But later on in the document for it, it says a 5-step process. Does it have to be 5 steps, or can it be more or less?
I'll be totally flexible on that. I think you probably knew that I would be. I
was just checking since I'm like 5 steps.
Yep.
We got a number.
All you need to do is say, I've opted not to make it 5 steps. I think it's more appropriate to be 3 or 30. Well, I'm glad you raised that. Thank you.
And then the second question was in regards to the second part. And it was in the form that you wanted it written in. Did you want it in the form of a memorandum of advice for, what was the name of the person in question? For Mary?
Yes.
Is it so it's a memorandum of advice for Mary?
I think that
as opposed to like a bloody what's the word I'm looking for? A political explanation or something.
Yeah, look, I think it can be in the form of a letter. I actually like memorandums of advice or an opinion. That type of format suits me, and I'm very happy to encourage you to do that if you're comfortable doing so.
And the final point is that we were told to only reference the fictional legislation and the Interpretations Act. That means you don't want, but does that mean we can still reference cases with regards to how interpretation works, or?
Yes, you can still. I'm just trying to not make it too broad. but you can certainly refer to cases. And I think, I'm not sure if you asked this question, Sarah, or who did, but on UCRU there was a question about referring to other materials like the Queensland Law Handbook. You can refer to those sorts of secondary materials as well. But just don't go looking for other pieces of real legislation.
Yeah. And then the final thing I had to ask was, where did I put that note for it? Sorry. Oh, because we obviously don't have an actual marine cleanliness legislation, do we have, like, is there a way we can figuratively mention that like how we would normally reference like objects clause, explanatory memorandum, all that sort of stuff with regards to interpreting that particular provision? But we obviously don't have that for this provision. So
No.
do we like imply that in the case of the interpretation, we would be taking notes from this, this, and this?
Yeah.
Yes, that's fine.
And this is where I actually prefer to base my questions on real legislation. So it would just be too much to write a full act. But I think it's appropriate to say that if given access to the objects clause or a definition clause, you'd be looking out for those sorts of things. But you can't go beyond that. But I think to acknowledge that that's what you would do, then you should do that.
Okay, thank you.
All right, so good questions there. Thank you, Sarah. Are there any questions about the second assessment piece in particular? I think we hopefully will all find where the material is. I should explain that I had to change the format slightly because I use SharePoint, and I just couldn't link to my SharePoint documents successfully. So I had a technological issue with the links. So that's why I created some documents separately in the additional resources section. So hopefully that's easy to find. All right. Now, are there any other questions, comments? All good? All right. Thank you very much. So next week is Christmas week. So it's a holiday. So enjoy your break. The week after that is New Year's week. And what I propose to do is have a recorded session for you to consider. And we'll be back live on Wednesday, the 10th, I believe, of January. All right. But you can go online on the Wednesday evening and chat amongst yourselves. The line is available, so you've still got that facility if you wish. Okay. All the best. Thank you very much for attending, and we will see you in a few weeks. Okay. All the best. Bye.